As long and to close the discussion about Article 8 infringement in Rotaru for failure to provide legislation which is in accordance to a sound law by Romania, a point should be made about supervision. Supervisory procedure are paramount in order to safeguard the legitimacy and the compliance of a given legislation about intelligence services with the fundamental rights of respect for private life, whereof Article 8 of the Convention. So in a legally sound system, data collection should always be supervised. Now, this is regardless of the fact that the data subject or the interested party is not allowed to file challenges or to refute the data and the records. It could be the case. It could be the case that for certain reasons, especially for temporary reasons, when an investigation is ongoing by the judiciary or also by the intelligence services themselves, I said it could be the case that data are not accessible, and in as much as they are not accessible, they are not even possibly the subject of any request by the data subject, the interested party, to the extent that supervisory procedures acquire a totally different and possibly even more important meaning in the fact that somebody should be in charge with such a supervision, and such a supervision which is aimed at safeguarding respect of the rule of law and of democratic principles and prevent abuses. Such an important task should be assigned to a judge, the court says, because a judge is the only figure that provides a sufficient independent and impartiality in order to guarantee respect for such an important principle, such an important democratic principle. Another issue has been addressed with regard to Article 13, the right to a remedy. Now, this is not dealing with supervision in a strict sense, but to the right of the data subject to file a request to destroy the file, to amend it, to correct it, in order not to have his personal data around, even in an incorrect and derogatory form, capable of undermining his reputation, for example. Well, as we saw in the overview of the case, my short description, the applicant could not obtain anything like that. It could not even get an award of damages. Instead, the courts ultimately held that the Secret Services had all the right and were in respect of the law when holding that file for an unspecified amount of time, even if it was passed by the previous Secret Services, that, by the way, probably were much more unregulated than the new ones, but this is not the point. And in as much as this is clearly an arguable claim of violation of a fundamental right, it must be met with a legal remedy in the system, in the national system. Basically, when you claim a violation of Article 13, you don't have to prove that you were right, that the violation occurred, but what is required is that there's an arguable claim, that it is something that can be argued upon, and that would at least reach an admissibility uh, before the judicial body taking charge of ascertaining violation of fundamental rights. So in this case, it was obviously an arguable claim. It was also a very founded one, by the way, and this triggered the finding of violation, which is probably not to blame on the judges, but on the legal system that did not did not provide any remedy. After all, the judges only established that it was simply not possible to award with a decision or a judgment something that could not be, because it was not envisaged by the law. So they had no power to do that. Now, after all this said, and all this lesson across its development, to sum up, the interesting news, the important news, is that, well, it might be true that in many countries, intelligence activities do not fall within the scope of application of data protection legislation, but even where this is the case, even where there are derogations, it is not enough to be intel, to violate Article 8 or any other fundamental right, because fundamental rights are always in place to the extent that they are not constrained under some justified reason, as long as they are not depending on a national legislation or a law, but they are principles, and they fully apply based on of the international treaties, and also even if they are not statutorily set forth by any legal instruments, sometimes as they are too fundamental, too entrenched in the legal system to be simply avoided, simply disregarded. On a more practical, but probably incredibly interesting note, I would stress that now the system of data collection and data gathering by intelligence agencies poses significant risks as to respect of fundamental rights, when it comes to the radicalization phenomenon. As you have seen in module number 1, that clearly sets out what radicalization is, and also describes complexity in defining such an important phenomenon, such a wide concept. When this is concerned, we might think that given the way Intel activities might be regulated, given the way they could derogate to data protection laws, and once we see that this is coupled with the undefined concept of radicalization, which on its side has been treated as some kind of criminal phenomenon, but on the other end is not even a criminal offense, we should really appreciate the risks that we are undergoing in letting this matter, this unregulated field of radicalization, fall within counterterrorism in its whole, and so open the doors to an arbitrary, undefined, and broad data collection that it's really in danger of not being compatible with the convention and with the fundamental right to private life. Now, in more practical terms, let's think about a file like in Rotaro case. We have a file. A file could be could include devastating news, devastating information about someone, like having, for example, a radicalized tag on the file. Suppose you had a radicalized file. Suppose there is a file about you in the secret, within the secret services, with a radicalized tag on the cover of the file. Now, nobody would like it. Okay, I would say this is no less than a bomb. It's just a bomb. It's just a bomb ready to explode. By the minute the file is out, is released, anybody and anyone access it, well, depending on who's going to use the data, what could happen could be to prohibit career advancement, or anyway, form extremely negative judgments, if not to allow for someone to be deported, to be separated from their families. All of this unbeknownst to the interested party that has no chance to claim anything about those data. So now, would you like to have a bomb hidden in your home where you live? Would you like to be such in danger because of something simply explodes and you don't even know where it is? Don't you think you have a right to know where the bomb is? It's your right. It's your right. And in this case, it's exactly the same. You have the right to know if someone holds a file where you are suspected of radicalization. This is as easy as that. It should be regulated. If not in principle, by the time the file is created, after a certain amount of time, the bomb must be switched off. It cannot remain dormant for the whole existence of the subject. This is simply unacceptable and allows us to understand and answer the first question, as why should we care about the right to private life when countering terrorism? And anyone carrying out such an important activity should be bearing in mind that we are creating bombs that must one day must be switched off. This is a fairness. This is a respect for fundamental right. This is democracy. And with this, I believe that I can close my remark, and I am thanking you for joining this module. And I'm looking forward to meeting you at the live session, where hopefully I'll face your concerns and doubt, which I'll be trying to answer and address to the best of my capabilities. Thank you once again, and have a nice day.